Advantage.
Can you flip it towards me?
Sure, I'll flip on the food.
Oh.
It's a long flip.
I know, I was gonna say, that's like serious, like arm.
Okay, we'll have a.
Yeah,
Booyah. Pay me the fuck. Yeah, that's all.
It's more fun to fuck with them. And really, it's all about our entertainment.
You said 6 off. Six off. Gender. State action. Alright. Go good.
First off, Calidate's point interpretation overruled means to make a decision void of the same grounds original decision or black slate 790 over express a judgment on the same question of law directly opposite that was violated was in violation of the plan rules and niceties are not the actual common cause clause reason for first limits the affirmative interpretation supposed to often include thousands of alternative ground change date or anything else that slightly modifies the issue. Next is ground voting precedent is key to all our ground standardized actions more following don't link in their interpretation. Next, legal precision our definition of legal sources we tend to find it that is a void of regret of jurisdiction and ground. Next, argument is counterplanned first text. United States Supreme Court should rule that the international governance of political rights sufficiently amplifies congressional 14th Amendment power to enact the federal civil rights remedy provision of the Violence Against Women Act. This is substantial overrule which solves their act and avoids the dissent guns in 2003. Just as overrule the teaching parties not even order overrules the mass act overruling with minimal damage to the court's legitimacy. Next is judicial salary. First, salary increase will pass down proceeding into the for office trying to uncouple judicial salary, professional salary, performance safety, and military salaries. And the Congress structure affirmative but not by cutting paid or challenge administrators in the crescent recent years left with the right to Congress to restrain or deny judicial salary adjustment. And that underwrites the rule of law according to any class of facilities of the judges around the world will highly qualified charges necessary for the rule of law. And that causes nuclear conflict right in the rule of law is even though that's hope for real nuclear warfare the rule of law. Next, EPA. First, the court's rule for the states in the EPA case right now, we're going to watch those that takes for a while. Supreme Court agreed to hear why the EPA the rule in the state's favor in the plain drains judicial capital to force you to trade off according to parity 99 just crazy about their case support opposition interest group political leaders and what is other position might harm its efforts. One, Charles not enough of that trade-off block with the EPA case to encourage sharply done six issues in the Supreme Court decision global war and America must not be fully binding also supposed to be reality and that leads to global warming. For New York Times 6 EPA is one of the most important environmental issues of America's trying to precisely discourage the rest of the world from precisely that causes extinction according to Diner. In 2016, this climate change will accelerate species extinction biodiversity loss global restoration. You're taking this economy will that next is Roberts. First, Roberts keeping the courts on a predictable windows class right now with the plan traces stable approach and cuts all legal predictability. Garrett that's Roberts respect President Roberts organized Roberts recognize the overrule that electric system Roberts policy grounded based upon predictability and the resulting uncertainty kills business confidence. He that's uncertainty is desirable change legal rules people have to hesitate their time and money pursuit of goals but toward and lack of business confidence kills the economy go toward that when business confidence collapses economies that possession specialty confidence where they'll buy bankers need to lend and economic depression causes extinction the party agreed to that by they'll want to unleash nuclear biological warfare they feel economic collapse to zero and major nation we get Armageddon. Next criticism. Turn to the Supreme Court for ethical action is negation of negative relation to life, legal system, meaning morality, reflects self-presumption back into annihilation for Party 2003. The majority which to restrain the ethical responsibility we cannot take in our hands because they're not strong enough to engage in self-destructive death with at least total annihilation, the area for justice, resignation, the face of dependability, the sense of legality can never be anything but exceptional states are part of rejection to will, life system, property, fighting against that would be a principle hostile life that has to assassinate the future of humanity, fail sign for secret path of nothingness. And the McKinnon discussion of gender falls into trap creating God, gender domination is an ontological, supposed historical element identity in which she recreates the very suppressive she criticizes Brown 95. McKinnon essentialized gender, making it fully production party, source, science, investment, class, sexuality, sexual, gender, ontological, right, historical criticism, ministry, restraint to the arrested for the state of postulate, justice, page, report, George Test, Mark, generalized, the guy, also many does the same thing, and generalized the pornography and sexual sexuality, will rationality over the Jerry model, gender, mirrors, the hyperbolic expression of gender, sexuality, late 20th century, self-produced women, and sexuality with their conception, sexuality, fundamental future, gender, indicator theory, short, stabilized female sexual domination, self-destabilizing, origin, reliable, gender subordination, and the concept of hate crime legislation operates according to logic. Oh, and the what the hell does this say? State action doctrine relies on a negative relationship of life, which is repoliticizing and violent, according to Morgan 2003. Any type of marginalized group secure the political, civil rights, government, civil sovereignty, individual with tragedies, surfacing the wounded, attachment, any politics, organized, but any politicized, nuclear responsibility, injuries that are undertaken in the world, in which unequal treatment is underpinning Western democracy, judicial system, politicization, within the occupation, race, the back legitimacy, claims of liberal capitalism, not tied to capitalist democracies, the lack of rights agenda, also the lack of the case of pedophiles, leader, non rights, the language, the language, time, the vote, prerequisite of moral, and policy where it's not a neutral legal tool, rather stands as paradox of avoid between advancing women's autonomous legal being and protecting their defenses, bodies from being battered and abused, paradigm constitutes women as being the most willful, knows their own big foot or pure competent harm war with a strategy based on their strata of oppression, according to 2003. Following case revised state Victoria Law, the woman is fear bring to what is been branch to be looking predator nations because it's capable of binary failures, risk complexities, and complete rhetorical structure and tangible effects on women's lives, professional unity enables a voice against shame and bad wives and other visible binary dichotomy and simple victim versus nature characterizations. The question of what about women experience are rare, crucial experiences concerning work, but a reason this focus attention to the definition of construction of women and battered women simultaneously prevails as medical treatment laws, like by this definition of moral soldiers, right? Or the strict relation to construction, strict dichotomy separating the autonomous from the victimized, and or alternatives to negative performance, criticism, limitation, implicit, and what is the representation disposed undermines the stability of static epistemological claims and opens terrain for new political possibilities. Criticism Hall stands by. Judges found enabling equal credit to creatures respect and necessary to turn around the question of the juridical question one hand, the judges all figured the capacity of judge and regime to the strategy missed but relying on philosophies and organizing classical configuration, so rationality itself, the critical existence of thought, internal question on the invoking negative moment, the ethical political moment, possibility, transformation, hopes of critical justice, going to linked to the virtue of critical negativity as both the disruptive element at first to the critical negativity, the rising possibility of responsibility, which with life is individually good creation, precisely here the trend that was down limit is located in gender balance. This is where it's anyone who put a dead gender balance is only symbolic if it's plea bar down anyway, go to Peter 99. False sponsors made with too little to reduce gender violence against women. People want to say I was thinking about raping that woman down civil rights women won't do so because many cases have been difficult to bring to trial because big people would enforce the plea bargains anyway. And the final alternative stolen gender violence is money and mandatory prostitution law is nothing. Raping 99. The battered women often willing to plead their abuses, making it rich and impossible. Most people promise financial battered women have the money to pursue a lawsuit. They better blue lie things will plaintiff get out of there. And gender violence is way down. Society is getting progressively more gender equal malnutrition. In 2018, carbon according to the public health better consistently larger plaintiff percentage of women being reported violence. Investment reports of rapists and failure dramatically for the back end rape will send things men estimated women economically intervention foster new and rejected violence against women. And symbolic advantages not needed more symbolic most of all attachment means are symbol advantages meaningless critical form 2000 more symbolic most of all attachments very breath of body stage reaction down with the response that comes as a reach of friendship victim regardless of the more sensation we better new or gender equality and better remedies can't overcome any structural limitations and the states according to Part 99 the executive reform against results of the political convention also constitutional limits and remedies states provide state officials more likely to over-enforce criminal laws and chiefly under person nor the restriction the remedies defending about constitutional state law toward remedies are more likely to pursue parallel federal 1 is 10. And childbearing in workplaces it is the internal link to public-private dichotomy that means childbearing is the link they don't solve for family needs 6. The fact that women bear children has been a major impediment to women become fully integrated stereotypes about pregnancy and creation more than any other factor to the achievement of women and the low-private economy and civil remedies irrelevant existence. The rest of all solve the public-private relations according to Kidman 2000. So society's not completely society encouraged kid only bounds against women who obeying legal support the public-private economy has been abated, but the legislature is fully accepted the role that must play in domestic violence. And the civil rights remedy is involved with nothing more than red herring that diverts resources away from real problems. Go to Reckon 99. The Mr. Lincoln is declaring that when a man does not do something, 6 years after abuse them, they're not getting better because the thought is a red herring man will just have the opposite effect for his invention. Will reveal for what it is a fad red herring. The lives we paid in wasted time and effort. The CRE will not cause any action to be taken in behalf of women. And the civil rights proceedings are worse than the criminal process of victims are based upon comparative fault, which blames away victims with their own rape or cross. In 2000, civil justice adversaries will compensated by comparative fault blames the victim for her own rape, comparative fault doctrine perpetrates that victim blame. And moving gender violence excluding the public to reinforce the underlying dichotomy itself or growth in 2005. Breaking the traditional notion of privacy, granting legal innovation made for respective creating a situation where women's control over the private domain, which wife use to public private games, reinforce the underlying economy, public life use, and led to the implementation policy that if women choice public series litigants seek remedies of the law are rhetorically configured as victim, nor established suspected women's work to move between the private and public. And the civil rights remedy restricts free speech by moving the person up to the criminal and instance ensuring gender apartheid according to McKellar. That's why. Well, guilt free speech and academic liberty, Americans pressing their illogical standards to many gender violence, civil rights remedy, press for honesty, evidence for life is water, gender violence, merely critical step, political gender violence against women has been steadily defining a state action doctrine. They don't remedy state action doctrine. The plan the rules on law why they can't be out applied to future cases. Anything they simply rule that there was a showing of state action doctrine in this instance of gender violence, not that state action doctrine is required at all. And this is especially true because Morrison isn't the source of the state action principle. The evidence concedes that Morrison just affirmed the civil rights cases which the act doesn't overrule. They have no evidence the state action doctrine will expect this will plan and overrule Morrison is totally insufficient. Their author agrees to win. You're getting to that vibe. The problems like Shelley, the problem civil rights cases, establish paradigm, and you can possibly form without opening short only with Shelley representative direct self-close board men with state action doctrine. The problem lies the artificial economy, so supposedly private government activity also refusing to control just to more time on the project with great events report. And at minimum, they can write the plan directly to address this argument. They would have to overturn the state action principle to really explicitly not just rule Morrison. Also, they have no evidence they will racism. They can't act as avoid their impact. Also, the court will swim back against your decision. Court found that by justice, the risk for being tool. The court's concern is telling remain that obviously the rest of the and that Supreme Court will distinguish why your decision court was that unless the facts are identical to the court will distinguish her case of boundary, and that will completely cut your solvency ban for 96. Legal fiction for legal communities will change into law. The court will find out so address the court will preserve ban to obvious fiction all along. And nothing about your half-breeds work from court to court.
Read experts.
Alright. And consequentialism is the key. This is on the view Isaacs in 2002. Unyielding concern not more business and provides moral responsibility for the attention. And when it does not have one goes to secure judges, the effects of pragmatic and promotes arrogance and undermines political effectiveness. And you're responsible for catastrophic consequences for shape from like that 2005. So scratch this. On time.
Alright, what's the status of the counterplan?
Our interpretation of negative fiat is that negatives get one test of your framework and one test inside your framework, but only two. And we choose, will be one of those two and two.
There's no straight
Hang on.
responsibility.
What are the net benefits to the counterplan? Under what conditions can you extend the counterplan in the 2 and R?
The net benefits.
Can
of
we
the
do
counter-
anything to make you go for it?
No, you can't do anything to make me go.
Okay, and what are the net benefits to the counterplan?
The distance.
Just the dissents.
Right.
Okay, all right, let's look at your first dissent. Your link evidence says the following. Roberts espoused respect for precedents. Robert recognized overruling might fatally electrocute the system. Roberts made abundantly clear that his philosophy of juridical modesty is grounded on predictability. That's your link evidence?
It says that
That's it?
undermining respect for precedent, overruling would be a fatal jolt to the legal system.
Do you have any evidence about Morrison?
We didn't read a more specific argument.
Okay,
You
now
undermine
let's
precedent.
look at your internal link, which is that it kills business confidence.
Right.
Certainty is desirable. If courts change legal rules, people will hesitate to risk their time and money in pursuit of goals that might be thwarted. That is your
There-
internal link argument.
The evidence
Where
indicates-
does it talk about business confidence?
That
Where
evidence
is,
says that people, when they're investing money, if there's an uncertainty in the legal environment,
so
they're
how does
less
the
likely to
Morrison
invest
decision
in
lead to uncertainty if we don't overrule on commerce policy?
That's the card you just read that indicated
This?
that they're uncertain of when the court.
Okay, so what legal regulations, like
I
what
mean-
companies would lose confidence in the economy after the plan?
Well, they're not certain what's going to be regulated
Which
anymore.
companies?
The states versus the federal government
Which
will be
companies?
entirely single.
What issues, like whether
First
private
off-
actor racism?
First off, there are
is a question of-
it's a question of whether or not they feel like the court will give them a stable legal environment. For example, if someone felt like they were going to be regulated at the federal level, like car companies, they would be certain that they'd have a uniform standard.
Why would the Clamp plan change that?
Because the Morrison decision was set in precedent that that would happen, and the states would regulate
What,
that. However,
the
this
states would
sets-
regulate car companies?
well, the states would regulate private actions.
Private
And
action.
our-
So post the plan, businesses will be uncertain because private action violence is.
No, I mean, businesses will be uncertain because the
Why?
court looks crazy, continually overrules
What
states.
regulations do, like, what
Actually,
regulations?
there is another link argument there based
What?
off the way
What?
the Morrison precedent would work, because the tort claims certainly change the way.
Where is that in the one in
employment
C?
environments would have to work.
Well,
This
that's
is
the
not a
reason-
hard
that's the
one. It's
reason
just
why-
a reason
Why
why
tort
That's the,
claims?
that's the reason why.
Why would tort claims create uncertainty in the business environment?
in employment politics and the way that people would have to relate internal to businesses, you don't think that a massive ruling changing the way that gender relations would disrupt or
Work in the
potentially
office place?
break in-
Why would that create, why does that,
Even
okay,
if the
hang
Mor-
on,
even if the
Mike, I
Morrison
have
decision-
not asked a question.
Okay.
My question is, how would, okay, so let's just say that the tort remedies is your link. As your internal link evidence says that this would be a regulation uncertainty. How is that a regulation?
Well, that's the problem. The Supreme Court is no longer maintaining the business's position as never uncontestable.
Okay,
If the
that's
Supreme,
fine.
even if
Which piece
Morrison
of evidence did
wasn't.
you read, the top or bottom?
Oh,
Okay, let's look at your evidence that says the massive, like the states are gonna win right now
Mhm.
is from, okay, the ununderlined part of your evidence says, the decision is momentous, said, and then this is the ununderlined part, said New Mexico Governor Bill Richardson, whose state is suing the administration along with 11 others. I'm confident the court will rule in my favor.
I mean, it says
That's your
confident
uniqueness
rule in the
evidence
state's favor. He
from a
also-
person who is saying that we think
I
we're
mean,
gonna
he
win
makes
this.
a lot of claims. He's like, I could.
No, actually, that's the end of your
He's
part.
like, I could rule this with hand puppets and still win.
Yeah, but you didn't read that part.
Okay.